Do you employ a domestic worker? Are you looking after their rights? Hi, I'm Simon Dippenaar and I'm an attorney. There are nearly 870,000 domestic workers in South Africa. They represent 5.2% of the population. Many of us rely on domestic workers to clean our homes, look after our children, and perhaps cook our meals. Anyone fortunate enough to afford help in the home has a responsibility, arguably a moral duty, to pay a living wage. According to livingwage.co.za, this is estimated to be 6,806 Rand per month, or around 320 Rand a day. Unfortunately, not all domestic workers have steady work 5 days a week, so a more generous daily rate will undoubtedly be welcome. But what happens if your domestic worker slips off a ladder while cleaning your windows or burns herself on a hot oven? Can she claim compensation from the Compensation for Occupational Injuries and Diseases Act 130 of 1993, COIDA? The short answer used to be no. Fortunately, a recent Constitutional Court decision has rectified this inequity. COIDA was designed to provide compensation to employees who suffer occupational injuries or diseases. However, Section 1 historically specifically excluded domestic workers, thereby denying them and their dependents access to compensation if they suffered injury or illness at work. If domestic workers had been included in the definition of employee under Section 1, then they would have been entitled to the full protection of COIDA and been eligible for compensation on a no-fault basis for injury sustained in the course of their employment. Now, no fault means they do not have to prove the employer was negligent. COIDA was designed to prevent the need for employees to sue their employers for work-related injuries. COIDA's funds are generated by contributions made by employers. Employees are not required to contribute. Now, benefits payable under the Act include temporary and permanent disability benefits, medical benefits, and benefits to the dependents of the employee where the employee died on duty. Domestic workers are among the most economically vulnerable groups in South Africa, so denial of access to this compensation perpetuated social economic inequalities. Unable to work and often not paid any sick leave by employers, a domestic worker could rapidly fall into extreme poverty. This discrimination also failed to acknowledge the significant contribution of domestic workers to the economy and society. In fairness, many employers do support their domestic workers through difficult times, but without the legal right to compensation, the domestic workers' situation was always precarious. Yet the reasons for this exclusion from the definition in the Act for so long is a mystery. There was no legal or rational basis for it. Now, the South African Constitution enshrines the right to equality and non-discrimination in Section 9. Excluding domestic workers from the Act benefits was discriminatory, as it denied a predominantly female workforce the same protections afforded to other employees. Furthermore, through this exclusion clause, South Africa failed to align its domestic laws with international commitments, including the International Labour Organization's Domestic Workers Convention. In a relatively recent Constitutional Court decision, the exclusion of domestic workers from the definition of employee under Section 1 of the Act was found to be unconstitutional. In Mshlangu and Another versus Minister of Labour and Others, the daughter of Ms. Mshlangu, a domestic worker who drowned in her employer's swimming pool, sought compensation for her mother's death. Ms. Mshlangu had been a domestic worker for 22 years and was partially blind and unable to swim. When her daughter approached the Department of Labour, she was denied compensation under the Act, along with unemployment insurance benefits. The matter ended up in the Constitutional Court, where the definition of employee under Section 1 of the Act was challenged. The Constitutional Court expressed regret for this exclusion and the prejudice it had caused to domestic workers over the years. The definition was changed and the order was made with retrospective effect from the 27th of April 1994. Domestic workers are now covered under the amended COIDA and can claim compensation for any injury sustained while on duty from the Compensation Fund. If you employ a domestic worker for more than 24 hours per month, you must register them with the Unemployment Insurance Fund, UIF. It is a misconception that this is only required for full-time workers. If a domestic worker is at your home 1 day a week, they are very likely to reach the 24-hour monthly threshold. If you have any questions about labour law and want to be sure you comply with all relevant legislation, or if you are a domestic worker and think your rights under the Basic Conditions of Employment Act are not being upheld, contact me on the number below.